good. Interaction is very much important when you are studying this kind of subject like law. Before I start the lesson today, I have to do an announcement on behalf of the institution. That is next Saturday and Sunday, both we don't have lectures. So you can have a long weekend, you can enjoy the weekend. There's no classes, no lectures next Saturday and next Sunday. Okay, we'll start today's lesson. It's a continuation of the previous lecture. If I summarize what we studied last week, we started the lecture about contract law. So then I said legally enforceable contracts. So before that, I said there are contracts. So some contracts are legally enforceable and some contracts are not legally enforceable. Legally enforceable means that if it is breached, that you can go to courts and can ask for remedy. All the contracts that you can't go to courts if it is breached, because some contracts are not legally enforceable. So what we have to understand, or what we have to identify when we have a case or when we have a question, whether a question on contract law, first of all we have to decide, or we have to identify whether that contract is legally enforceable or not. If it is legally enforceable, then you can go to courts and ask remedies. But if it is not legally enforceable contract, that means if it is not a valid contract, so then even it is breached, the innocent party can't do anything, or in other words, no remedy, because the contract is not valid. So to identify whether the contract is valid or not, I said there is a test for that. What is the test? To see whether the contract is legally enforceable or not, I said there are 7 elements. 7 elements. So if those 7 elements are there, those 7 elements are fulfilled, then the contract that we can consider as a legally enforceable contract. So then now I said there are 7 elements. So what are the 7 elements? First element is the agreement, then intention, then we have consideration or justa causa. Then I said the next one is the contractual capacity, then the legality of the contract. The 6th one is true consent of the parties. 7th is the form or formation of the contract. So then we start studying each and every element in depth. So the first one we discuss is our first element we studied. We started to study agreement. Agreement, I said the first element, it has 2 parts, that is offer and acceptance. Agreement equals to offer plus acceptance. That is the equation that I gave you for easy understanding. So you can see the agreement, it has 2 components. First is the offer, then the acceptance. Then we started studying of offer. We studied this in depth, and then we have to start from here today. Acceptance. Offer, I said offer is a promise which is capable of acceptance. Offer is a promise made by the offeror addressed to the offeree. The offeree can accept it, and we said the offer can be made to a particular person or to a group, a class of group, or offer can be made to a world at large. So then we discuss how the offer can be terminated, or how offer can come to an end. So those we discussed. These are the methods that the offer can be terminated. That is by death of the offeror or the offeree. Then by the occurrence of a condition, that we said if the subject matter of the contract or the offer is destroyed. For example, I said if I have a vehicle, if I offer to sell the vehicle, if the vehicle that is a subject matter of the contract or the offer, if it is destroyed before we enter into the contract, then the offer is not valid, because even if it is accepted, even the offer is accepted, that I can't perform the contract because the subject matter is destroyed. It has destroyed because of a occurrence of a incident or condition. So therefore, offer then we have to consider as terminated. Then the third one, offer can be terminated or can come to end by rejection. If the offeree reject the offer, then the offer comes to end. Then the other one is the counter offer. If offeree, instead of accepting the offer, if he make a counter offer, then the offer comes to end. For example, if I offer to the offeree my vehicle for 5 million, if the offeree reject it, say that I can't accept your offer because it's too high, then it's a clear rejection. So then the offer comes to end. So later the offeree can't change his mind and say that okay, I will buy 5 million, because then there's no offer to accept. So offer comes to end. The counter offer means instead of accepting the offer, so he can suggest a counter offer. Instead of accepting the price, he says 5 million is too high, so I would like to buy for 4 million. What is that? That is not an acceptance. So that is a counter offer. When a counter offer is made, the original offer comes to end. So that means my promise. So my promise to sell the vehicle for 5 million is no more, comes to end. So then the counter offer is the promise which has made by the other party. So that is the offer that I have to then accept, the counter offer. So that when a counter offer is made, the original offer comes to end. So that is number 3. Then number 4, lapse of time. Lapse of time means when I make the offeror, the person who make the offer, we call him offeror. As I told you the previous day, when you are answering law paper, that you have to write the correct law words, right? Legal words rather, right? So therefore the offeror, offeree, these words you have to be very familiar. So the person who makes the offer is the offeror. If offeror, when he is making the offer, if he stipulate a time period, if he mention a time period where the offer valid for example, we say that I offer to sell my vehicle for 5 million, and I say if you accept, you have to accept within 7 days. Or when I'm making the offer, I say I will sell my vehicle for 5 million. This offer is valid only 7 days or 14 days. So likewise, we can put a date or expiry period in the offer when we are making the offer. So if time is mentioned in the offer, so after lapse of the time, after the expiry of the time period mentioned in the offer automatically comes to end. Then the second one is when there is no time limitation is mentioned. No time is mentioned in the offer. So then what is the situation? Then the offer, you can't say when the time is not mentioned, expiry date is not mentioned, you can't argue that the offer is valid forever. You can't say so. For example, if I make an offer to sell my vehicle for 5 million, that doesn't mean that after 10 years someone can accept it. So the offer is valid only a certain period of time. Then thereafter it consider as valid, not valid or terminated. So if the time is not mentioned in the offer, after a certain period of time, it comes to end. So what is the time period? It's a reasonable time period. That's how court interpret that. The reasonable time period, the court will decide based on the case. For example, if I make an offer to sell a vehicle without a time limitation or expiry date, that offer, the court will interpret that the offer is valid for 3 months or even 2 weeks, because we never know. So 2 weeks is a good time or reasonable time. So then thereafter, court can interpret that the offer has come to end. But if I offer to sell a land, then if I have not mentioned the time period, so the court will interpret that in different way. So that court can interpret the offer is valid maybe 6 months or maybe 1 year, depending on the nature of the offer, depending on the nature of the contract, or depending on the nature of the transaction. The validity period of the offer can be changed. So there is no hard and fast rules to say this type of offer is valid for this period. Likewise, we can't say it's a totally the interpretation is totally dependent on the nature of the transaction. So that is number 4, lapse of time. Then the 5th one we discuss is by revocation also offer can comes to end. By revocation means the offeror, the person who makes the offer, can revoke the offer, can cancel the offer before it accepted by the other party, the offeree. Before it accepted by the offeree, the offeror can revoke the offer. So those are the 5 methods that an offer can comes to end. So that is the summary of what we learned last week. So then we have to start from there, I believe. So the second part of the first element of the legally enforceable contract. The first element is the agreement. Agreement, it has 2 components, offer and acceptance. Offer we discuss. Then now we are going to start here the acceptance. In Sinhala we call this Pratigrahanaya. Offer, Arpanaya. The Sinhala word is Arpanaya. Acceptance is Pratigrahanaya. Right? So the acceptance. What is acceptance? Acceptance is, this is a definition, unconditional consent. Very important. You need to write each and every word of the interpretation. You can't avoid any words. If you avoid any word, that means the interpretation is wrong. It is not just consent to the offer, it is unconditional consent. Very important. To all the terms of the offer. So that is another important part. So the acceptance in a simple meaning or simple interpretation is unconditional consent to all the terms of the offer. Now, one party is making offer, right? I will explain this. We say we are going to create a legally enforceable contract. Legally enforceable contract. So there are 2 parties. One party, we have the offer pro. The other party is the offeree. Right? Offeree. So then this offeror makes an offer. He makes an offer. Offer is a promise. As I told you, it's a promise. So when he is making offer, he put conditions. Condition number 2, 1, 2, 3, he put conditions. Then the offeror, so rather offeree, has to accept this offer. Accept the offer to create an agreement. So once it is accepted, then there is an agreement. To create an agreement, offer has to be accepted. What is accepted? Acceptance means that the offeree has to give consent to all and each and every terms of the offer. Otherwise, what will happen? It is not properly accepted. So this, you can see the offeror make the offer. By when he is making the offer, he put conditions, 1, 2, 3 conditions. That is a promise. That is a promise. Then the offeree has to accept all the conditions of the offer. Then, if it is so, then it creates a valid acceptance. Then offer and acceptance, it creates an agreement. That's how it works. So then the offeror can require any form of acceptance. When the offeror is making an offer, that he can mention what is the mode or the mode of acceptance. For example, when the offeror is making the offer, he can say, you are accepted, you send by way of a post, in writing, by post. So that then the mode of acceptance is mentioned, or by post, or by email, or by SMS, by fax. Likewise, he can mention the mode of acceptance. So the important thing here is, when the mode of acceptance is mentioned in the offer, the offeree has to make that acceptance. That acceptance has to be made in the same manner as mentioned in the offer. So, for example, if offeror says that you have to send your acceptance by an email, the offeree has to make that acceptance by way of an email. So, when the mode is mentioned. When the mode is not mentioned by the offeror, the offeree can choose a mode of communication of acceptance by his or her choice. Then the acceptance is not effective unless it is communicated to the offeror. So these are very important when it comes to the contract law. First element that we have to decide whether there is an agreement or not. When to decide that, as we discussed, there are two parts in the acceptance. First, we have to identify whether there is a valid offer. Once we decide there is a valid offer made by the offeror, then the second step that we have to go into the other part or other step and see whether there is a valid acceptance. So to decide that, you have to see the legal requirement of the acceptance. Legal requirement of the acceptance. Just an acceptance is not a legal acceptance, in other words. So therefore, those elements or those legal requirements must be fulfilled to create a legally enforceable or legally valid acceptance. One important legal aspect is the acceptance must be communicated to the offeror by the offeree. If it is not communicated, then the acceptance is not valid. Now, for example, now one party, the offeror, make an offer to the offeree. The offeree like the offer. That person has the intention to accept it, but didn't communicate the acceptance to the offeror. So in that case, the offer is not valid, offer is not complete or effective because it is not communicated to the offeror. Now, for example, if we take this the same example, we say that the offeror, when he's making the offer, his first condition is that if you accept my offer, you have to send a letter. Letter of acceptance you have to send. Now this lady, she accept she wants to accept the offer. She write the letter of acceptance. She writes a letter, but didn't post it. Instead of posting the letter, she kept the letter with her. Now, what has happened? Letter is written, but it is not communicated yet to the offeror. So therefore, since the communication is not fulfilled, the the acceptance is not valid. Acceptance is not valid. So therefore, it is very important. One important point is acceptance must be communicated to the offeror by the offeree. So that is another important point. Then silence is not an acceptance. This is another important point. When the offeror is making an offer, the offeror can't say, offeror is a person who makes the promise, he can't say that if you don't reply to my offer, that I consider you have accepted my offer. So you can't put a condition like that, because the silence is not an acceptance as per law. Now, for example, we say now this person, when he's making the offer to the offeree, so he put a second condition, or rather first condition, he say, okay, we say the second condition, first condition he say, if you accept my my acceptance, my offer, you have to send your acceptance by way of a letter. He put another condition and say, if you don't reply to my offer, I consider that you have accepted it. In other words, it says, if you are silent, then I consider that as an acceptance. However, as per the decided cases, there is a case that I have mentioned here, Feldhaus versus Bentley. In that case, 1867 decided case, it very clearly says silence cannot be considered as an acceptance. So therefore, it has to be communicated. The acceptance has to be communicated to the offeror by the offeree. Unless it is communicated, the acceptance is not valid. The mode of, or the communication mode, offeror can decide. If it is not mentioned in the offer, the offeree can decide the mode of communication. So those are the elements, some of the elements of, or rather legal requirement of an acceptance. Do you have any questions from this slide? Or do you need any clarification on this slide? Right. If you don't have, then I'll go to the next slide. Right. Requirement of a valid acceptance. Legal requirement of valid acceptance. Number one, should be made while the offer is still in force. In other words, if I explain this, the offeree has to accept the offer while the offer is in force or in operation. For example, we say the offeror make the offer to sell a vehicle. And the offer says the offer is valid only 7 days. So the operation period is mentioned there. The operative period is only 7 days. The offer is valid 7 days. Now the offer made to the offeree accepted the offer on the 9th day. We say it's accepted the 9th day. So then the question is whether the acceptance is valid. If it is valid, then there is a legal, there's an agreement between A and B, the offeror and the offeree. So the law says the offer has to be accepted by the offeree before it expired. So therefore, the first element is the acceptance should be made while the offer is in force. There is a case that I have mentioned here. You don't have to remember all the cases, but if you can remember the cases, that is good, because then you can earn extra marks. You know, the case laws, when you write case laws, you get extra marks for those. Remember, the case law or the case references are the icing of the cake. So therefore, when if you know the cases, then you can decorate your cake with a nice icing. So then you get extra marks, you get attraction, and you get extra marks. So therefore, it's good if you can remember the cases. So if not, at least remember the theory. But there are cases, when I say these are very important cases that you have to remember, those cases that you have to remember. So otherwise, if you write the theory without the case, that you will not get the full marks. For example, last day that I said, Carlyle versus Carbolic Smoke Ball Company Limited case, I said it's a very important case. And you have to remember the case and also the facts of the case and the judgment or the law decided by that case, that you have to remember. So likewise, that when it is very important, I say that you have to remember the case. So in this case, this matter, the case that is not that much important, however, if you can remember, good, right? Then should be made by the offeror or his authorized agent. Second point, the acceptance should be made by the offeree or his authorized agent. Now, if I explain this, we say now A is the offeror. He makes an offer to B, right? So B is the offeree. Instead of B, C accept the offer. Offer is addressed to, I'll take this, and we say this is A and this is B. Now, this boy is making an offer to B. Now the offer is addressed to B. B has to accept the offer. Then the agreement creates. However, instead of B, C accept the offer. C accept the offer. She wrote the offer letter, and so rather the acceptance letter, and sent to the offeror A. The question is whether there is a contract between A and C now. A and C. A make the offer to B. Instead of B, C accepted the offer. The question is, there is an offer, there is acceptance. Sorry. Whether there is an agreement. Whether there is an agreement. Whether there is an agreement. The answer is there is no agreement. No. There's no agreement. Reason, offer, offer can be accepted only by the offeror, rather the offeree, or offeree's agent. So if C is not the offeree's agent, then there is no contract between A and C. That is the other important point that you have to remember. Then the fourth point is, third one, should be clear, absolute, and unqualified. The acceptance, it has to be very clear. So you have to clearly say whether you are accepting or not. Right? For example, you can't say, I like to accept. So that can be interpreted in a different way. When you say I like to accept, so that means that you have still not accepted, but you like. Right? So you can't make an acceptance like that. If you accept it, you have to say I accept. So very clearly you have to say that. Number one. And it has to be absolute. Absolute means it's a final decision. Right? You can't say I need time to accept, or I need to consider. Likewise, it can't be put a condition or put a condition like that. It has to be absolute. So final, absolute, clear decision. And the next one is unqualified, without any condition. Without any condition. So you can't put a condition in acceptance. You can't say, I accept your offer if you stop smoking, or if you stop taking liquor. That's a condition. A boy making an offer to a girl, girl say, I like to accept your offer. That means not accepted yet, because it is not clear, absolute. Right? You can indicate your acceptance without saying accepted. That is also not legally valid, because it is then not absolute or clear. Then you can't put a condition also saying that I like to accept I accept your offer if you stop this, or if you do this, if you do that. Likewise, you can't put conditions. If you put a condition, that is not a valid acceptance. There's no agreement between them. So therefore, it is very clear. The third point is, the acceptance should be very clear. It has to be absolute. It has to be unqualified, without any condition. So those are very important points. And the fourth one, should be communicated to the offeror either orally or in writing or by conduct. This is very important. If the mode of communication is not mentioned in the offer. I'm repeating again, listen very carefully. If the mode of communication is not mentioned in the offer, the offeree can either orally, by words, orally, or in writing, by way of a letter, or by conduct, also can accept. Example, right? Verbally, orally, you can accept. You can give a call to the offeree and offeror and say, offeree can make an offer to the offeree can take a call to the offeror and say that I accept your offer. That's a verbally or orally that acceptance communicated to the offeror by the offeree. Then in writing, so you can write a telegram, or you can send a telegram, or you can send an email, or you can send a letter. So that is a mode of communication by writing or by conduct. Verbally or orally, or in writing you don't write, but you accept the offer by conduct. For example, we say someone offer, for example, say your friend has lost his pet cat, and he said, look here, I lost my cat. If you find the cat, I will give you 100,000 rupees. So that is his offer. So you don't want to communicate him that you have accepted the offer, or you don't have to write it. Now you can start searching the cat. So that is by conduct, you have accepted the offer. Now your friends knows that you are looking for a cat. So that is the offer. He has communicated to the offeror by your conduct. So the offer can be then accepted by orally, or in writing, or by conduct. So these four points, legal points, are very important with regard to the valid acceptance. So these are the requirements. In other words, these are the requirements of a legally valid acceptance. So up to now, if you have any questions from this slide also, you can ask now.
Excuse me, sir.
Yes.
Sir, the second requirement,
yes.
that agent case.
Yes.
It is needed to mention the agent when accepting the offer.
Yeah.
I mean,
yeah. Your question is whether when the offer is accepted by the agent, whether it is needed to mention that it has been accepted by the agent. Is that correct?
Yes.
All right. Okay. Good question. Of course, yes. If if the offeree is not the person who is accepting the offer, that means the agent. If agent is accepting, that you have to mention that you are the agent of so and so. That has to be communicated to the offeror. Otherwise, the offeror doesn't know who is that person who has accepted the offer. Now, for example, we take a real example. The example we say company A. The offeror is a company. Offeror is a company, right? So offeror company makes the offer to the other end offeree. Offeree also is a company. Offeree is a company. Now you know when we say company, company is not a natural person. So company can't write a letter to accept. So someone in the company, the second company, that is the offeree, has to sign or has to write the letter and sign the letter. The person who signed the letter on behalf of the second company, that is the offeree, is the authorized person. He has to be authorized by the company to accept the offer on behalf of the company. If he is not authorized to accept the offer, then the offer, so rather the acceptance, is not valid because that is not the agent, authorized agent of the company, offeree company. So therefore, the person who writes the letter of acceptance has to mention that he is the agent of the company, and also actually he has to be appointed, he has to be authorized by the offeree company to accept the offer. Is that clear? Is that answer is enough for you, or you want?
No, sir, it's clear.
Right. Any other questions?
Yes, that it is need to mention of offeree's agent into the offerer. That means how the offerer should identify or identify the correct agent.
Okay, right. So yes, it has to be communicated to the offeror. Otherwise, as you said, the offeree doesn't know whether that person is the authorized agent or not. So when the offeree company or offeree, he is appointing an agent on behalf of him, that he has to communicate to the offeror that he has appointed an agent. Now, for example, in real world, when we appointing somebody on behalf of us, we appoint that agent by way of a document. We have a document, say, power of attorney. So I can appoint somebody on behalf of me to act on behalf of me by signing a power of attorney. So the agent, when he's signing the document on behalf of me, that he has to show the power of attorney to the other party. So then the other party will realize, understand that the person who signed the agreement, or rather the acceptance, has authorized to do so by me. I am the principal, he is the agent, so I have appointed him as an agent. I can appoint him as an agent by a document. Or there are other ways that I can appoint an agent, so that we are going to study later under the agency law. So for the time being, remember, that's a good question, whether that agent has to, the offeree has to communicate that I have appointed an agent. It is important that it has to be communicated to the offeror by the offeree. Is that enough, or you have any other questions?
No, sir, it's clear. Thank you.
So other students, do you have any questions up to now? Because next we are going to discuss a legal principle. The first legal principle next we are going to study. Do you have any questions? Okay, right. So then I assume that you have understood very well the offer and acceptance.
Excuse me, sir.
Yes.
Please explain third requirement.
I can't hear you. Can you speak a little bit louder? What do you want?
Please re-explain that requirement.
Still, I can't hear you. Can you speak a little bit louder?
Please re-explain third requirement.
Third requirement. Oh, okay. Third one says should be clear, absolute, and unequal, unqualified. That is the one you need to explain, right?
Yes, sir.
Okay, right. Right. I will explain now. Right. When the offeror is making an offer to the offeree has to accept the offer to create an agreement. When the offeree is making the acceptance, it should have some qualities, some characters. Now I said, what is the offer? Offer means the promise made by the offeror to the offeree. When we are making an offer, we put conditions. We put conditions 1, 2, 3. Likewise, we put conditions. So the offeree has to accept all the conditions. However, when we are making an acceptance, that acceptance has to be very clear. For example, if we are accepting an offer, we have to clearly say we have accepted the offer. Now, for example, I gave the example. I will take the same example. We say A here. We make an offer to B. B wants to accept the offer. Right? B wants to accept the offer. B say, I would like to accept the offer. So those are the words that she has used. I would like to accept the offer. So that what does it mean? So that means she is still considering. She is like to accept, but she has not finalized it. So it is not clear to the offeror whether she has accepted my offer or not. So therefore, it has to be very clearly communicated without any condition, without any doubt that she has accepted it. For example, she has to say, I accept your offer. So that is very clear. When you say, I accept your offer, that means that is final. That is very clear that I have accept your offer. All the conditions that you have put, I accept. So that's very clear. Then absolute means that is the last decision of the offeree. So there's no any other room to the offeree to reconsider the acceptance. That is absolute, final decision. Final decision. So if for example, if we say, I would like to accept your offer, but I need time. So that means that you have still not accepted. That is not absolutely decided. It is not final. It's not final. Absolutely decided, not decided yet. So you need further time to consider. That is also, if you say like that, that is not a acceptance, right? It has to be final. When you say, I accept the offer, that shows it's very clear. It is absolute, no more room to consider. And the next point is unqualified or unconditional. So unconditional means you can't say, I accept your offer subject to these conditions. I accept your offer if you stop smoking. What does it mean? So that means still the girl has not accepted the offer because she has put a condition. So you can't put a condition in a acceptance. If you put a condition, the acceptance is not valid. So then there's no agreement. There's no agreement. So it has to be simple, very clear, absolute, unqualified acceptance, like I accept the offer. So that is very clear, absolute, and also without any conditions or qualifications. So is that clear?
Yes, sir. Thank you.
Right. Any other questions?
Excuse me, sir.
Yes.
If offeree accept the offer the last day through writing, and offerer received the acceptance after 1 day, so 2 days, is that is valid?
Good question that we are going to discuss in our next slide. Okay.
Okay, sir.
Any other questions from this slide?
Excuse me, sir.
Yes.
So there's a question. If an offerer make an offer to offeree, let's say they made to a group of people.
Hmm.
So the offeree is asking more time from the offerer, but
Oh,
another
I
person
didn't follow it.
accepted the offerer.
The last part
Yeah,
I did not clear. Can you repeat it again? Offeror is making an offer to a group of people.
People, yes, and one offeree, asking for more time to accept the offer.
Right.
But since this is made to a group of people, another person accepting the offer.
Right.
So what will be the about that person who asks more time from the offerer?
Okay, very good question. You have think lot. Very good. Right. So offer is made to a group of people. Right. One of the people of the group has said that I would like to accept your offer, but I need further time. So then that is not a valid acceptance. So, right, that is not a valid acceptance. Meanwhile, somebody else in the group without any conditions very clearly, absolutely accept the offer. So then what happened? Then immediately after the valid acceptance is made by one of the person in the group, agreement created between the offeror and the offeree. So no one else in the group thereafter can accept the offer, because once it is accepted, offer comes to end. Then thereafter the agreement. So others, with regard to others, there's no offer to accept once it is accepted by one person. Then once it is accepted, agreement creates between the offeror and the person who accepts the offer. Is that clear?
Yes, sir. Yes.
Right. Okay. So then, shall we go to the next slide then? Because of the time factor, so I'll go to the next question, next slide. We are going to discuss the first law principle in our lesson. This is called the Postal Rule. Postal Rule. This is a repeating exam question. Right, so therefore it is very important. You can highlight or whatever the slide. Postal rule. The first rule, the principle, the law principle that we are going to discuss. Right. One student before the last question, the previous question, asked a question. She asked if time is given in the offer letter, we say 7 days, and if it is accepted on the 7th day by the offeree, and if the letter is received by the offeror later, say 9th or 10th day, whether the acceptance is valid. In other words, that is in simple words, if we put into that in legal words or legal language, if the offeror makes the offer with a time limitation and the offeree accepts within the time limitation, but the communication is made later, that is after expiry of the time, whether there is a valid agreement. So that is the question, right? So we'll answer to that question after we studying this principle. The principle is called Postal Rule. Postal Rule. Now, remember, all the students, you must remember very, very, very thoroughly, this Postal Rule applies only to the acceptance, nothing else. First thing that you have to remember, the postal rule applies only to the acceptance. Number one. Number two, the postal rule applies to the acceptance only when the acceptance is sent by post. Sent by post. Postal letter. Right? So these two conditions that you have to remember. Right? When I say it is applicable only to the acceptance, don't put the postal rule to the offer. These are the common mistakes that you do in your exam. When we give a case study, right? People write answers, they say postal rule apply to the offer. So that means that you have not studied postal rule properly, or at least you have not studied the principle correctly. So it is applicable only to the acceptance. Postal rule will not apply to the offer. Right? Postal rule apply only in the contract law. Don't put postal rule to in other area like sources of law or anything. It's applicable in the contract law. It apply to the agreements. It apply to the acceptance, not to the offer. First one. The second one, it is only applicable when the acceptance is made by way of a letter, postal letter. That is why it is called postal rule. Tapal reethia in Sinhala. When you say postal, it is postal. So then it is for the emails, for the SMSs, for the fax or any other communication, telegrams or whatever. So it will not apply. It will apply only to the postal letters. So these two that you have to remember very carefully. So keeping those 2 points in your mind, we'll see what is this postal rule. Right? So as I told you before, I said there is a legal requirement to have a valid acceptance. The acceptance must be communicated to the offeror by the offeree. Think again, right? Offeror makes an offer to the offeree. Offeree accepts the offer. And it has to be communicated to the offeror. Unless it is communicated, the acceptance is communicated to the offeror, the offer is not complete. Offer is not complete. So that is the main requirement. That is one of the main requirement of a valid acceptance. Now, we know when we put a letter into the post, sometimes it get delayed, right? So then the time can lapse during the letter transmit from A to B, offeror to offeree. So in a situation like that, what is the principle? What is the law applicable? So this is the principle applicable in a situation like that. When the offeror send the acceptance letter by way of a postal letter, postal rule applies. Right? So then it says communication of acceptance will be complete and effective at the point when the letter of acceptance is posted or placed into the hands of the relevant postal authority, not when it is received. Listen, now read very carefully, one by one, right? Now this is about the acceptance. One important point of the acceptance is you have to communicate the acceptance. The offeree has to communicate the acceptance to the offeror. The question is, at what point that we have to consider the communication is completed. Communication is completed. For example, if we send a letter, say I am the offeree. I write the letter, put into an envelope, sealed it, stamped it, and put it in the letterbox, right? And it takes 3 days to go to the offeror. Offeror take the letter. Offeror take the letter. The question is whether now the acceptance is communicated to him. He got the letter but didn't open yet. Right? We say a servant of the offeror has collected the letter and kept on the table. Right? On the table. So after another 3 days, the offeror opened the letter. After another 3 days, it was kept on the table 3 days, and after 3 days, the offeror see the letter and he opened the letter and he read. The question is, at what point the court has to consider the communication of acceptance is communicated to the offeror. Is it the time that the letter came to the address of the offeror? Or is it the time that he actually received the letter, the offeror? Or is it the time that he actually read the letter? Those are the questions that we have to answer. So there is uncertainty in that. So therefore, this principle has been developed. What is the principle? The Postal Rule. It says the communication of acceptance will be complete and effective at the point when the letter of acceptance is posted. So in other words, if I am the offeree, if I write the letter, then after I put into the envelope, seal it, paste the stamp, put into the letter box. At that point, as per the postal rule, it is considered the communication is completed. Communication is completed. Right? Not the day that it has received to the offeror. Clear? You have any questions? Right, okay. So then I believe that everyone understood the principle very clearly. So it says the communication of the offer, rather the acceptance, is complete and effective at the point when the letter of acceptance is posted, not when it is received by the offeror. So there is a case that I have mentioned here, that is Adam versus Lindsay. Very important case. When I say very important, you can't write the postal rule, the answer for the postal rule, a complete answer for the postal rule question without writing this case, Adam versus Lindsay. Right? If you write the theory part, you get only half mark. If you write the case, then you get full marks. So therefore, it is very important. This is the second important case in so far. First one is Carbolic Smoke Bowl Company case. Then the second one is this one, Adam versus Lindsay. So what happened in this matter? D, that is the offeror, sent a letter of offer to sell some wool to P. P is the offeree, right? He sent a letter. D sent the offer letter to P. D is the offeror. P is the offeree. he sent the offer letter. So when we say offer, we send the offer letter, that means he has to send a letter in post, right? So he sent this letter on the 2nd of September. 2nd of September, he posted the letter. Then he requested an answer by from P by post. So he said the mode of acceptance also mentioned by post. So then he has to send the acceptance by post. Then what happened? The letter was misdirected and did not reach to P until 5th of September. So what happened? This letter got misdirected and went here and there. Ultimately, it reached to P, that is the offeror, on 5th of September. 5th of September. Took 3 days to reach. Right? Then on the same day, he accepted the offer of P accepted the offer, and he put this into the letterbox of the postal department. Put into the letter. So then, what happened? Had the offer been properly directed, an answer should be received by D by 7th of September. So if it is not direct not misdirected, by 7th of September, under normal circumstances, that acceptance letter should come to D. So D thought if it is on the 7th of September, he thought there's no acceptance letter from the other party. So therefore, he thought that it has not been accepted. So then what happened? For the 8th of September, since there is no acceptance, so what he did on the 8th of September, he sold this bull to somebody else. You say S. He sold to somebody else. Now, on the 5th of September, the letter of acceptance was posted by P, but it reached to the offeror on 9th of September. 9th of September. Now what happened? On the 2nd of September, he posted the letter. And under normal circumstances, within 2 days, it has to go to P, that is 4th of September. If 4th of September offeree accept it, by 7th maximum, it should come to D. Now D waited but didn't receive an acceptance by 7th. So on the 8th of September, he sold the wool to somebody else. So then after selling the wool on the 9th of September, this letter of acceptance came to him. Letter of acceptance came to him. The question is now whether there is an agreement between D and P. Whether there is an agreement. If there is an agreement, what will happen? There is a breach because D has sold now the wool to somebody else. Then what was the decision of the court? Court said the contract was formed by 5th when P accepted it was posted. D was therefore in breach of contract. So now you see, when we apply the postal rule, what happened? Once the offer is accepted by the offeree, law consider as under the postal rule, the communication is completed and effective. So in this case, what happened? On the 5th of September, the offerer, or rather the offeree, has accepted the letter or accepted the offer and has written acceptance letter and has posted the letter on the same day. So that means the communication of acceptance considered as fulfilled or effective. So therefore, then offer is accepted, then there is an agreement. What is the agreement? D agreed to sell wool to P. Now the letter went to D on the 9th. By 8th, he has sold the wool. Now there's no wool to sell to P. So what happened? P filed action against D. What was the decision? Court said, once, as per the postal rule, when the letter is posted, the acceptance is complete. So therefore, when the acceptance is complete, offer and acceptance is there, there is an agreement. By selling the wool to somebody else, that D has breached the contract. So therefore, he has to pay damages to the other party, that is P. So that was the decision. So that is postal rule. Anyone, if you have questions on postal rule or any clarification, or if I need to repeat, please you can ask your question now. Anyone has questions? Or all clear? No questions? Okay, good. So then I'll go to the next one, right? Then the other important point of postal rule, it is possible to the offerer to expressly or impliedly reject the postal rule. So that means the offerer, the person who makes the offer, when he's making the offer, he can say to this transaction or to this offer, the postal rule will not apply. So if he say, if we put a condition like that, the postal rule will not apply, or otherwise postal rule apply when we send a letter of acceptance by post. So this is postal rule. Right, so then I'll go to the next one. Rules applicable to communication of acceptance. Right, rules applicable to communication of acceptance. What is the first rule? Number one, it must be carried out by the offerer or his so actually it has to be carried out by the offeree or his authorized agent. Please, we have to rectify that. There is error. It has to be carried out by the offeree, not the offerer. It has to be carried out by the offeree or his authorized agent. So the acceptance has to be made by the offeree or his agent, nobody else. Right? That's number one. Number two, the acceptance is not effective unless and until it is communicated to the offeror. Again, the acceptance is not effective unless and until it is communicated to the offeror. So offeree has to communicate the acceptance to the offeree. But there is an exception here, that is the postal rule. As per the postal rule, when the communication is made by way of a postal letter, right? So then the communication is considered effective from the time the letter is posted. So apart from that, acceptance is not effective unless it is communicated to the offerer. For example, we say now we send a letter, we send an email. The acceptance by way of an email. By a technical error, technical issue, that email didn't go to the offerer, didn't receive. So then the acceptance is there, but it is not communicated. So therefore the acceptance is not valid. Then number 3, an offer may not state that the offeror must not state that the silence shall amount to acceptance. That we studied, right? Offeror, the person who makes the offer, cannot say that if you don't hear anything from you, that I consider you have accepted my offer. That is not a valid acceptance. You can't put a condition like that. It has to be verbally, in writing, or by conduct. The acceptance must be communicated to the offeror. Then the next one, communication of acceptance by post is subject to postal rule. We studied that. When the communication of acceptance is done by way of a postal letter, it is subject to the postal rule unless the offeror has rejected the postal rule. So that is number 4. Number 5, the acceptance may be in the form of express word or implied by conduct. So as I told you, the acceptance can be done by word, by writing, in writing, or by conduct, by doing some act. So that is number 5. Number 6, acceptance must be communicated in the precise way stipulated by the offeror unless an equal, quick, efficient, reliable method is chosen. So this is a new development of law. Previously I said when when the offeror says that the acceptance should come in a mode, the offeree has to accept the offer in the same mode. For example, if offeror says that the acceptance should come by way of a letter, then the offeree has to write a letter. But the law says that the acceptance must be communicated in the precise way stipulated by the offeror. So that is number 1. Number A, the precise way. If offeror says by letter, you have to send a letter. If offeror says by email, you have to send an email. But when it is not mentioned there, you can choose. The offeree can choose, or the offeree can choose a equally quick, efficient, or reliable method. So, for example, instead of sending a letter, you can send a telegram. That is quick and also reliable. Reliable as the postal letter. So, likewise, you can the offeree can choose equally quick, efficient, and reliable method to communicate the acceptance. So those are the law relates to acceptance. So we have now completed the first part of the first element of the legally enforceable contract, that is an agreement. Agreement has 2 components, offer and acceptance. Last week we studied the offer and the law applicable to offer. Today we studied the law applicable to acceptance. So offer and acceptance is completed. So now you know what is an agreement. So if you have any questions from acceptance, you can ask now. If you have any questions. Okay, since there's no questions from you, so I presume that you understood acceptance very well. So you are now thorough with the first element, that is agreement. So then I go to the second. I will continue from there. We are going to discuss the other elements of legally enforceable contract. I said there are 7 elements in the legally enforceable contract. We studied the first element. Now today we are going to start from there. That is the second element we are going to discuss now. That is the intention. Intention. In singular we call it abhipraya, or we can say adahasa. Intention. So what is intention? We said to come to an agreement, minimum we need two people, minimum two, offeror and offeree, right? Minimum two people we need to create a contract. Offer is the promise made by the offeror. Acceptance is the consent of the offeree to the promise. Now, when the offer and the acceptance is made by the offeror and the offeree, an agreement is created. What is the second element? Second element is the intention. What do you mean by the intention of the parties? Intention of the parties means what? The idea to create a legal relationship. In simple language, the idea of parties of a contract means the idea of the intention of the parties means the idea of the parties, that is the offeror and the offeree, idea to create a legal relationship. So when you are making an offer and when the other party is accepting the offer, they have the idea or they have the intention to create a legal contract. So that is the second element. So when you get a case, you have to see both the offeror and the offeree, whether they had the intention to create a legally binding effect. Now, if I give an example before that, in every contract there is an agreement, but every agreement is not a contract. So, example, domestic agreements and agreements among friends. Now, when we say a contract, we have an agreement. There are agreements, so there are offers and acceptance between people, but they don't have the intention to create a legal relationship or legal contract. Now, for example, when the domestic agreements or domestic arrangements, right? When we live with our parents, our siblings, right? Our cousins, so we make promises. When we make promises, others accept. So then the offer and acceptance is there. But those are not, the offer and acceptance creates an agreement, but the agreement is not a contract. It is not converted into a contract. Agreement, domestic agreement will not convert to a legally enforceable contract because the parties, the offeror and the offeree, do not have the intention to create a legal enforceable contract. So intention is not there. Right? Now, for example, your parent, your father or mother can make an offer to you. So he or she can say, if you pass the exam, I will buy a car for you. Right? Now that's a offer. That's a promise. Right? And it has condition. Condition is that you have to pass the exam. So you say, okay, okay, Dad, I will work hard and I will pass the exam somehow. So now you have accepted and communicated to your father. Now there is an agreement between you and your father. Now both parties, now you have to perform the duties under the contract or the agreement. What is your duty? You have to pass the exam. Once you pass the exam, what is the duty of the father? Has to buy a car. Now you work hard, you studied, right? So then you somehow pass the exam. So your part now you have completed. Now the father's part. You say, Tata, Dad, I passed the exam, so I have fulfilled my part of the contract or agreement. Now you fulfill your part. You have to buy a car. Then your father says, I am very happy that you passed the exam. You are very good, right? But you know that I can't buy a car. I don't afford for a car. So just forget about it. You have a good future because you passed the exam. I'm happy for you. So what is that now? You have fulfilled the contract, your part of the contract. The father has now breached the contract. He promised to buy you a car. Now he say no, can't, no money. Now it is very clearly breach of a contract. Question is whether you can go to courts and file action against your father and ask remedy, ask damages. You say your father said,
No.
yes. Okay, right?
No, sir.
You can't do that because there's a reason. What is the reason? Is there an offer there? Is there an offer? Yes, there is an offer. Father made the offer. Whether there is an acceptance? Yes, there is acceptance. You accepted it. Whether there is agreement? Yes, there is agreement. Whether you have performed the agreement? Yes, you have performed the agreement. Whether there is a breach of agreement? Yes, there is a breach of agreement. Father has not performed. But still, I say that you can't go to courts and ask any remedy against your father because there is a lack of one element. What is the element? Element number 2, the intention. Your father does not have the intention to legally enforceable contract with you. When he made the promise to you to buy a vehicle, he didn't mention or he didn't expect that you will go to courts and file action against him if we don't buy a vehicle. So because that is a domestic agreement or domestic arrangement. When we live in a domicile, when we live in a house, every day we make promises. Others accept our promises. And always we breach promises. But each and every time when the promise is broken, we don't run to the courts and file action. Not because that we can't, because it is not possible under the law, because it is a domestic agreement. Then another example is agreement among friends. So when we meet our friends, we make promises. Our friends accept our promises, and friends, they make promises. We accept their offers or promises, and also we breach their promises, our promises, and they breach their promises. But each and every time we don't go to courts and file action against our friends, because those are also, there is agreement, but those are agreements among friends which are not considered as a legally enforceable contract. To create a legally enforceable contract, the parties must have the intention to be legally bound by their agreement. So then it is very important. This is the test that you have to do. When a person is making an offer, when the other party has accepted the offer, you have to see whether the both parties, that is the offeror and the offeree, had the intention to create a legally enforceable contract. So that test that you have to apply and see the intention of the parties. So then the parties must intend to be legally bound by their agreement. So from this slide, do you have any questions before I go to the next one? Intention of the parties, are you clear, everyone? Okay, then I'll go to the next one. The parties must intend to be legally bound by the agreement. So we studied that the intention is the parties, both parties should have the intention to create a legally enforceable contract. So legal presumption. Legal presumption. There is a legal presumption with regard to the intention of the parties. Presumption means purva nigamanaya. In Sinhala we call it purva nigamanaya. Right? Presumption. When we go to courts, the law presume. There's a presumption. Right? That is decided or considered as correct. What is that? First one, if it is a commercial agreement, so listen very carefully, right? If it is a commercial agreement, in all commercial agreements, the presumption is the parties intend to create a legal relationship. So this is the first presumption. The question before the court is whether the parties had the intention to create a legally enforceable contract. So then the court will look into the agreement or the contract. If it is a commercial agreement, the principle or the presumption is the parties had the intention to create a legal relationship. But we'll get an example for a commercial agreement. What is a commercial agreement? We take an example like this. Customer of a bank obtain a loan from the bank. It's a personal loan. He obtained a personal loan from the bank. Right? So then customer and the bank sign an agreement. So the question is whether both parties, that is the customer and the bank, had the intention to create the legally valid contract. The customer say, I never intended to have a valid contract. So he can say so. But court will not accept that because the nature of the contract is a commercial contract. It's a commercial contract. It's not a domestic contract. It is not a contract between friends or social contract. It's a commercial contract. So if it is a commercial contract, the legal principle or legal presumption is parties always had the intention to create a legally enforceable contract. So that is number one. So I have given here a case that if you can remember the case or otherwise just forget about the case, just remember the principle or the presumption number one. Presumption number two, if it is a domestic or social agreement, what is the presumption? The presumption is that the parties do not have the intention to create the legal relationship. If it is a domestic agreement, the presumption is domestic or social agreement. The presumption is there is no intention of the parties to legally enforceable contract. So that is number two. Now, with regard to this one, domestic and social agreements, I have given a case here, Balfour versus Balfour. This is decided in 1990. Balfour versus Balfour, very important case. When I say it's very important, it's very important. Balfour versus Balfour, with regard to the domestic and social agreements, it's very important. What happened in this matter? The wife of a man working in Ceylon had to remain in England for medical reasons. So during this period, as you know, before 1948, we were a colony of a British government. So this British citizen, he came to Ceylon, at that time Sri Lanka called Ceylon. He came to Ceylon to work, but his wife, she couldn't come because she has some medical issue. She was sick, so therefore she couldn't come. So only the husband came. The husband promised to pay her an allowance of 30 pounds per month. So husband promised, when he come, he promised that I will send you 30 pounds per month. Every month I will send you 30 pounds. So what happened then after he came here? So he failed to send money to his wife. So then his wife filed action against him. So now there is offer, there is an acceptance, there was an agreement between husband and wife. Husband breached the contract or agreement. Then wife filed action against the husband. So what was the decision of the court? It was held the agreement was not intended to have legal force because it is a domestic arrangement or agreement. So what is the presumption? If it is a domestic agreement, there's no intention to create legal binding effect. So then court held the agreement was not intended to have legal force, so wife couldn't get any relief. So the case failed because of that. So that is about the intention of the parties, the second element. If you have any questions from that point, that is element number 2, intention, that you can ask now before I go to the next one. Do you have any questions? Okay, since you don't have any questions, you have questions?
No, sir.
Okay, right. So
No,
then
sir.
I'll go to the next one. The next one is third element, consideration or justa causa. Consideration or justa causa. Consideration means, a singular meaning of the consideration is pratishtava. Consideration is pratishtava. Pratishtava. Consideration. Justa causa means sadharana hetuva. Sadharana hetuva. Justa causa means sadharana hetu. Pratishtava is consideration. So what is this? The third element. Consideration. Consideration is an essential element of a valid contract in English law. Right. Okay. Now, under the sources of law, we studied our common law is Roman Dutch law. Right. Dutch people, they introduced the Roman Dutch law into the country. So afterwards, it became the common law of the country. Before that, we studied, we had a Sinhalese law system. Then it was replaced by Roman Dutch law. And after British came, they also followed the Roman Dutch law, but they introduced English law for the certain areas of the law which were not governed, the areas which were not governed by Roman Dutch law. Now, in Sri Lanka, we have a mixed law system. We have Roman Dutch law, we have English law, we have Kandyan law, we have Desavalami law, we have Muslim law. Likewise, it's a mixed laws of the country. So therefore, some part of contracts are now governed by English law. Right? For example, I said the British people, they introduced certain industries into the country. One of those industries are banking. So the banking business is governed under English law. Then insurance, that is another the industry introduced by British people to the country. So there was no provisions in the Roman Dutch law to cater to insurance industry. So therefore, British law or English law applied to solve matters with regard to insurance. So now the insurance law of Sri Lanka is governed by English law. International trade also governed by English law. Likewise, there are certain areas of industries or areas are governed by English law. Now, the consideration is an element under English law. It's an element under English law. So consideration is an essential element of a valid contract in English law. So first of all, when you get a question, when you have a issue in contract law, you have to see whether that the contract is governed by English law or common law, Roman Dutch law. If it is a issue, or if it is a question, or if it is a contract governed under English law, you have to see whether the consideration is there. Whether the consideration is there. Justa causa or good reason is an element under Roman Dutch law. That is the difference between consideration and justa causa. One difference. Justa causa or good reason, a valid reason, is an element applicable to the Roman Dutch law contracts. So once you realize or once you understand the contract is governed by Roman Dutch law, then it is not the consideration, it is good reason applies. What is the meaning or what is the idea of this consideration or justa causa? It means the both sides or all the parties of the contract must give something to the contract, or all the parties, in other words, all the parties of the contract must contribute to the contract. So that is what meant by consideration, right? So all the parties who participate for the contract should put a value to the contract. So that is the idea. Type of consideration can be classified as a good consideration, bad consideration, or valuable consideration, or nominal consideration. Now, what is the difference between this consideration and a good reason or justa causa? Now, we'll take examples, two examples, right? We'll take sales of good. Sales of good. You go to a shop and you buy something, right? That is an agreement between the seller and the buyer. Sales of goods are governed by English law. English law. Then element is the consideration. Consideration means that you have to pay a value. Pay value. So you buy something. We say you buy a packet of milk powder. So you buy it and you pay the value by rupees, by cash. So that is called the consideration. You pay the value. So then agreement create between you and the seller, shopkeeper. Then we take another example. The gift. Gift. Gift is a concept or a contract governed under Roman Dutch law. Gift. So when we, in Sri Lanka, when we gift, for example, we say, your parent gift a land to you, right? Gift a land to you. It's a gift. It's a legally contract. It's a legally enforceable contract, legally valid contract. But you don't pay a consideration. When you get a gift, you don't pay the value. If you pay the value, that is not a gift then. Then it is a sales and purchase. Here, when you get a gift from your parent or when you get a gift from somebody, you don't pay the value in rupees because that is governed under Roman Dutch law. So therefore, the justa causa applies. Justa causa means a valid reason, a good reason. Now your parents, they have a valid reason to gift a property to you. Unless there is a valid reason, the gift is not valid because the justa causa is not there. What is the valid reason that your parents have to give a property to you? The reason is because you are their child, they have love and affections towards you. Love and affection. The love and affection is the real reason or the good reason to give a gift. So therefore, even though the consideration is not passed, even though the value is not passed, there is a good reason, there is a justa causa, so therefore the gift is valid. So that is the difference between the consideration and justa causa. So you have to see whether the contract is governed by English law. If it is a contract governed by English law, consideration applies. If it is a contract governed by Roman Dutch law, you don't want to bother about the consideration. You have to see whether there is a justa causa or a good reason. Right? When we take the consideration we can classify into 4 categories. Number 1, the good consideration. Number 2, the bad consideration. Number 3, valuable consideration. Number 4, nominal consideration. Good consideration, bad consideration, valuable consideration, and nominal consideration. Those are the 4 types of consideration. To have a legally valid contract, the consideration must be a good consideration and also valuable consideration. Good and valuable consideration. Then I have given a case here, right? So if you can remember the case, that is fine. Anyway, that is, if it is possible only, or otherwise you just forget about the case, right? That is about the consideration. Then the principles govern. The principles govern in the consideration. What are the principles applicable to consideration? Consideration need not to be adequate, but must have some value. That is the first requirement of a valid consideration. Consideration need not to be adequate, but must have some value. What does it mean? Nominal consideration, first one, consideration need not to be adequate, but must have some value. What do you mean by that? I will explain like this, right? Now we say, now I have a vehicle, where the market value of the vehicle is, we say 5 million. 5 million. So I want to sell my vehicle to a friend of mine. So I offer the vehicle and he bargain and he say, I will pay 3 million. I say, I have only 3 million. I will pay 3 million. So market value is 5 million. He is offering me 3 million. So I accept and I sold the vehicle to him for 3 million. Now the consideration pass between us is 3 million. Actually, that is not adequate. Adequate means it is not equal to the value, real value. If it is the real value, it has to be 5 million. Now, actually, it is not so. It is not adequate. But however, consideration or the agreement is valid because the consideration need not to be adequate. So, if I am the owner of the property, I can sell the property for a lower price. That is my discussion. Just because I sold the property to a lower price, that doesn't mean that the consideration is bad. Still, the consideration is good, even though it is not adequate. Then the second one is must have some value. It should have a value. Value means it should have a reasonable value. Now 3 million he has paid. My friend paid 3 million. So that is a reasonable or good value paid. So therefore the contract is valid. Contract is valid. Then the next one, nominal consideration. The consideration may have some value which is insignificant in relation to the transaction. Now, for example, we say we take the same transaction. So we come into a contract, or I sold the vehicle, but he only paid 1,000 rupees. 1,000 rupees. So that it has a value. It is not adequate. And that value paid by my friend is not sufficient also. So it's just a nominal consideration, just a value, but it's nominal. So therefore, that type of consideration is called a nominal consideration. As we know, the nominal consideration is not good for a valid contract, right? It has to be good consideration and it has to be a valid consideration. The consideration need not to be adequate, but must be real. It must be capable of being quantified. So the consideration, it should have a value. We should be able to quantify it. Quantify means that we could be able to measure it by rupees or by dollars or whatever. We should be able to measure it. Now, for example, if we say love and affection, can you put love and affection as a consideration? So you can't put love and consideration because you can't measure it. You can't. Can you say that your father's love is only rupees, we say 1 million? Or can you quantify it? You can't quantify. So the love and affection is a good reason under Roman Dutch law, but not under cannot be considered as a consideration under English law because you can't measure it. You can't quantify it. Then the second point, consideration must not be passed. So that means that you can't take a consideration or value that you paid previously in past for a present contract. So normally the consideration is provided at the time of the creation of the contract or at a later date. So when we are entering into the contract, we pay the consideration, or we pay the consideration after we entering into the contract. Right? We don't pay the contract. We don't pay the consideration before we enter into the contract. If we have paid the contract, if we have paid value before the contract, that type of consideration is called past consideration. So consideration given before the contract is called past consideration. So that is about principles governing consideration. So consideration is the element consideration and justa causa we have discussed now. If you have any questions from there, if you have questions from here, the consideration or justa causa, you can ask those questions now. Do you have any questions?
So can you repeat the last one you said?
Last one means consideration must not be passed, that part.
Yes.
Okay, I will explain it again. Okay. Normally, now I will give an example, then you will understand, right? So you want to purchase a land, right? You want to purchase a land. When you are purchasing a land, what do? You go, seller and the buyer, you go to a lawyer, you sign the transfer deed, and after signing the deed, you pay the consideration. You pay the value of the land after you signing the deed. Right? At the time of signing or later, you give the consideration. That is the proper way to give the consideration. But there are cases, there are instances, there can be instances where that you have paid the value to the seller previously. For example, we say A has given a loan to B. A has given a loan to B. 5 years ago, A has given a loan to B. Loan 500,000 loan to B. Now, after 5 years, A is purchasing the land of B. B has not yet paid the loan. A is purchasing B's property and signing deeds, and A says, the money that I have given you as a loan should be considered as the consideration of this transaction. So that is called past consideration. Consideration you have paid well before you enter into the contract. So therefore, that past consideration under the law is not considered as a valid consideration. So you can't basically put that past consideration as per the consideration of present contract, because it is not acceptable under the law. So when you are entering into a contract, that you have to remember, you have to pay the consideration at the time of you entering into the contract. That means if you are entering into the contract today, if you are purchasing a land today, that you have to pay the consideration today. Or you can pay the consideration later. That means tomorrow, day after tomorrow, you can pay. But not the money that you have paid previously, 2 years back, 3 years back, you can't consider that as a consideration for this transaction. So that money that you have to recover, the loan, you have to recover separately, but that cannot be considered, or that cannot be set off against the transaction here. So that is called past consideration. Are you clear about that past consideration?
Yes, sir.
Okay, children, do you have any other questions?
Excuse me, sir.
Yes.
So could you repeat again the nominal consideration?
Okay, nominal consideration, right. The first part of the consideration says consideration need not to be adequate but must have a value. That part you understand, no? If it is a consideration, it should have a value, right? You should be able to quantify it by rupees or by dollars or whatever, right? You should be able to quantify it. We'll get an example. We say now we are purchasing a land, right? We say the land value is 5 million. Then the purchaser has to pay the value in rupees or in dollars. It should be a quantifiable amount. So that is called a consideration. Now, in certain transactions, right, you may have seen or you may have heard some people put only a nominal value for various reasons. Now, some people put a nominal value to avoid tax, right? So you can put you purchase a land. The actual value of the land is, we say, 10 million. 10 million. But for the deed, you put one rupee, or we say, forget about 1 rupee, 10,000 rupees. 10,000 rupees. Consider, when you consider the 10,000 rupees to the value, real value of the property, the actual value of the property, 10,000 is not sufficient. It's not sufficient. It is not adequate anyway. It is not sufficient also. So that type of consideration, the money, the amount that you put into the transaction is considered as a nominal consideration. Nominal consideration. So under the law, the nominal consideration doesn't accept as a valuable consideration for a contract. So therefore, you can't put a nominal value to a contract. You have to both, the consideration is the parties, both parties has to contribute to the contract. So if one party is putting 10 million property to the contract, the other party has to pay the value 10 million or something close to 10 million. You just can't put 1 rupee and purchase a land. Most of the time, this kind of transaction they happen when they want to avoid stamp duty and government taxes. People, they put a nominal value to the transaction. So what will happen if it is challenged in courts? That deed will not valid. The court will say you have only put a nominal value or nominal consideration. The nominal consideration cannot be considered as a acceptable consideration under English law, so therefore cannot be accepted. So that's why we say it's a nominal consideration, it's not a sufficient consideration for a valid contract. So it has to be, it should have a sufficient value. Need not to be adequate. Adequate means equal to the real value. It is not necessary to be, but something close to real value. So that is called adequate, right? Is that clear?
Yes, sir.
Right. So then it's 5:30 now. So we have to stop at this point. From next day, we will start the fourth element, that is capacity to contract. From there onwards, we will continue. So as I told you at the beginning, next week, Saturday and Sunday, both, we don't have lectures. So we'll meet then thereafter, not the next week, thereafter, fourth week we will meet on Saturday, 3:30. Thank you very much. You have notes with you. You have now holidays. During this holiday period, go through the notes. You have to prepare your own notes. Remember that these slides or these notes, it's only a guideline. You have to read, you have to understand, and you have to make your own note and study. So this is only a guideline given to you for you to ease your study. So thank you very much for your participation. If you have any questions when you're studying, that you can note down your questions, and you can, next day also I will give you time to answer questions. So during that period, you can ask questions from the previous lessons. And also, again, I'm telling you, when I'm doing these lectures, time to time, slide by slide, I ask questions. I ask whether you have questions, then you can ask your questions. Your contribution, your interaction is very much appreciated for this lesson. Thank you very much.